Welcome to Case Closed, the Contingency Fee Podcast. On the show, our team of industry experts interviews contingency fee attorneys. You will discover everything from how they got started to the secrets of their success and what's working in today's marketplace. And now, here's the Case Closed Podcast.
Ladies and gentlemen, we are doing another session of the Case Closed Podcast with Jesus Moises. Jesus, how are you doing this morning?
Very well. And yourself?
I am doing great. So tell me your background. Where did you go to law school? And what did you do before you had your own firm?
So I went to law school at St. Thomas University School of Law down in Miami, Florida, where we're based out of. After law school, I started off doing BP oil spill class action litigation at a firm called Farrell and Patel, where we had clients all across the Gulf Coast from South Padre Island, Texas, all the way to Key West, Florida, and everything in between. And we were essentially representing businesses like hotels, gas stations, restaurants, you know, any kind of business that suffered an economic loss due to the oil spill.
And do you currently do class actions?
No, currently we are primarily a insurance litigation law firm.
So you do slip and falls, auto accidents, truck accidents?
Mostly property insurance disputes. We deal mostly with first-party insurance disputes where it's the insured having a dispute with their own insurance company versus third-party, where like in a personal injury, situation where it's someone suing someone else and their insurance, kicking in if they have it.
All right. And what's your most famous case?
Let's see. So most famous case, probably the one that garnered me the most notorious would likely be the De La Hoz case, which was a case versus a carrier that I am under confidentiality with, so I can't disclose too much, information. But our clients had a hurricane dispute with their insurance company related to property damage that they suffered as a result of the storm at their property. And that case was in litigation for about 3 years. And just before the eve of trial, the insurance company filed a confession of judgment for the full amount of the damages being sought.
Okay. And what is the largest case, without telling me the name, what's the largest dollar case you've had?
Largest dollar case was it was a commercial claim, also a hurricane claim, and I think it was in the neighborhood of about $7 to $8 million.
Okay. What is the best advice you've ever gotten, and who gave it to you?
So the best advice, well, I'm assuming you mean legally applicable,
No,
or just in general with life?
In general in life.
So my temperament has always been one where, I set a goal, I hit it, I move the line and push further, hit that, push further, hit that, push further. So I've always been on kind of a focus on results and achieving results and results, and never, focused on the process itself and enjoying the process essentially. And I can tell you that I went off on my own in 2013. That was when I started my own law firm, and I was a solo practitioner. I didn't even have, a receptionist. And I always had this kind of, anxiety and just rush that I was always in, because I felt that my, colleagues were further along in their professional careers than I was. So I always was, comparing to outside, third parties, like what my standing was and how much success I had, achieved or not achieved. And I was honestly, driving myself crazy, because you're always, trying to control results. And there's so many variables that happen in between that are outside of your control that, you really can't control the outcome. You can only control what you do during the process. So as soon as I forgot who it was, but they gave me advice that, essentially I was focusing on the wrong part of the equation and I needed to focus more on the micro and on the process and not on the end result, and more enjoy the ride kind of thing. Once I started, pivoting my thought process to that, it really completely changed, my approach as an entrepreneur, as an attorney, as a father, as a husband, all around, because tasks that seemed, insurmountable were now, not even on my mind, because I was dealing with the more micro aspects of it and just kind of, chugging along every day.
And you're more successful doing that, right?
Yep. Yeah. Because I'm not worried about, am I where I want to be, 5 years from now, kind of thing.
What's the greatest frustration in practicing law?
The greatest frustration in practicing law, truthfully, is that it's kind of like a thankless job, I think, because, it's kind of like the new dentist, right? Everyone used to hate the dentist. They didn't want to go to the dentist. There was bad news every time you went to the dentist. I mean, I represent plaintiffs, so people come to us when they have a problem, right? And they're not coming to us willfully, happily, cheerily. They're coming to us anxious, worried, sometimes in a state of despair. And we're engaging in litigation, which in and of itself is a time-consuming and elongated process. So the two things tend not to mesh very well with each other. So the most frustrating thing is you have a client that's been wronged by some other party, normally the defendant in the action, and normally in this situation, an insurance company that has endless resources and endless time, and they don't have to live in a damaged property, so they're fine. So they can drag out the litigation as long as they want, and the entire way your clients are chastising you, their attorney, thinking that you're not working on their case, you don't have their best interest at heart, you're too busy for them, you're not paying attention, you're a bad attorney. So the frustrating part of it is where you're doing your best work for clients and they're not necessarily privy to it, because the things that you do, especially in litigation, most of the time don't really involve your client unless you're responding to discovery or you're preparing them for a deposition. But they don't see the depositions that you take of the other side, of their experts, of their corporate representatives, So while all of that is going on in the background, you then have to kind of deal with the emotional, terroristic aspect of, just being berated by your clients because they think that you are just not working on their cases and it's your fault that they haven't gotten paid and that their case hasn't resolved, and they're living in a house or a property that is developing mold with their kids. So it gets frustrating because you can't really defend yourself, even if you show them, the docket of the case. I mean, it's stuff that a lot of times they don't have the sophistication to understand. So you just kind of have to take it, and you're kind of like a punching bag all around. You're a punching bag for antagonistic opposing counsels that, believe they drink the Kool-Aid and they believe that there's no such thing as an intellectual battle. It has to be like an egotistical, nasty battle. So you deal with that. You deal with, problematic clients, and then trying to comply with all of the rules and regulations of the Florida bar so you don't, upset them, right? And then there's the judges too, and every judge has their own unique personality. So it's the frustration is, the tightrope that you have to walk in order to keep all of the necessary parties appeased for your life to have a decent, kind of level of being able to sleep at night.
So, Jesus, with the new statute, the one that was passed 2 months ago and the one that I guess was passed last week, where they're going after the adjusters. Have you considered the following two theories to use: RICO and civil theft?
Yes. So I think that ultimately what's going to happen, truthfully, is, I've been in the industry long enough, going on about 10 years now. So I do think that regulation was necessary, because I do think that there were bad actors out there that were gaming the system. I don't think that that was the primary cause of, the situation. I think that was caused by just the frequency of the amount of natural disasters that the state has seen in a very short period of time, as compared to prior to that, where we had a period of about 10 years or so with no storm activity making landfall. So I think that the storms put a lot of pressure on the carriers, which in turn put a lot of pressure on the reinsurance companies. The reinsurance companies had to raise rates on the carriers. The carriers, don't want to deal with kind of like the brunt of that. So they're passing it on to, the consumers. They've always been trying to pass favorable legislation. I've been involved with this since 2019, when they passed the first iteration of the assignment of benefits statute. And I knew that, the writing was on the wall, and they were going to continue to push, the fraud narrative, the bad actors narrative, the litigation is out of control narrative. And ultimately, I thought that they were going to get what they wanted. So I was always kind of brainstorming since then and preparing, for other things. If the insurance industry were to clean up its act, now that they have, the most favorable legislation literally that they could ever ask for, because the only more favorable thing is people are not allowed to file claims. So now that they have that legislation, you would expect them to do an about face and all of a sudden clean up their claims handling, treat people fairly, do the right thing, all that kind of stuff. I suspect that they're just going to double down on, well, now these people are even less armed, so we can, beat them up more. And I think that if they take that approach, it is going to open the door to class action lawsuits against the insurance companies, where you round up, homeowners or property owners all affected by the same thing, whether it's a storm, whether it's cast iron pipes, whatever the case may be, that are all in the same position, and you file one class action lawsuit against, the insurance companies, most likely related to insurance fraud on their part, which is where the RICO would kick in.
All right. Well, let me ask you the following question. What do you think, with all the claims that, like the most recent carrier, without naming names, I'm not probably supposed to do that, the carriers that went under,
yes,
legitimate claims, you think FIGA is just going to stroke the check after the 6 months and not spend all the litigation to defend him?
I think so. With FIGA, it's a little bit of a double-edged sword, right? Because once you're dealing with the private carrier, obviously, your claim to fees as an attorney is grandfathered in with that carrier. But once it shifts over to FIGA, they have no obligation to honor your attorney's fees and costs. So now it puts the plaintiffs in a position where, the attorney is, if their contract says this, has now switched to a contingency percentage. And depending on the size of the claim, it may be feasible to continue litigating it and try it. But if the claim is not, like if you have a $20,000 claim that went to FIGA, even if you have it on a 40%, retainer agreement, if you're talking, taking it to trial, your max recovery is $8,000. If you have to hire an expert and pay for a depo transcript and the filing fee, and a couple court reporters, that $8,000 is gone. That doesn't even include.
So what? Give you a hypothetical. $300,000 claim, house gets sold, so the claim plus the personal is probably $190,000. 3 separate claims on the prior carrier over a 2-year period that the original carrier didn't pay. Okay. In that scenario, would you think FIGA is going to try and settle because it's almost $200,000?
Nope, no chance. And if they do, when FIGA is attempting to settle cases, it's the state at the end of the day picking up the bill based off of the fund that they created by taxing every premium for every policy sold in the state a certain percentage to have this as a backup plan in case carriers went under. So they're going to handle and administer that money far more responsibly and, conservatively than private insurance carriers typically do. So
how much do you think it costs to try that case on the defense side?
On the defense side, probably somewhere between $50,000 and $100,000, I would say.
So when they settle between $50,000 and $100,000 to get rid of the exposure?
That's what I was going to say. If they do put an offer on it, I mean, you're looking at probably 30% of what the plaintiff was trying to recover potentially just as like a cost of defense. You know what I mean?
Yeah. Well, ladies and gentlemen, Jesus is very bright. I was a defense attorney for many years. He would be an intellectual challenge, which means he's the kind of attorney you need to hire. If you need an attorney in Miami-Dade or Palm Beach County, hire Jesus. Ladies and gentlemen, that is the end of this Case Closed podcast. Thank you, Jesus, for attending.
Thank you for having me.
Thank you for listening to another episode of Case Closed, the Contingency Fee Podcast. We hope you enjoyed listening to this week's guests and their insight. If you liked what you heard, please consider subscribing wherever you listen to podcasts. Case Closed, the Contingency Fee Podcast, is led by industry experts who unlock insights from the nation's top contingency fee attorneys. Each week on the show, the guests share how they got started, secrets of their success, and what's working in today's marketplace. Guests on the Case Closed podcast include successful contingency fee attorneys that will share their secrets so you can close more cases. Tune in each week for a dynamic conversation about winning legal strategies that will grow your business.